If I could have your attention, please, we're going to go ahead and get started. As we always do, if you would bow your heads with me, we'll begin with a word of prayer. Lord, we thank you for allowing us to gather here today as the House Judiciary Committee. As we always do, we ask that your wisdom be in this room. Help us, Lord, to move ahead in a manner that would be good for this state. Bless us and keep us. Thank you for all the blessings that we do have, Lord. We also, as we've recognized, there is a great deal of sickness not only in our nation but in our state and in this world, and we pray for that situation as well. Amen. All right, thank you for coming today. Representative Heath Clark will be first with his House Bill 479. You have a substitute in your folder, members of the committee. This is a substitute which I have worked with Representative Clark on. I would start out by saying that we have probably had more hearings in the Judiciary Committees over the past 5 or 6 years, particularly for those of you who haven't been here very long, on this one issue of the sexual molestation of children than we have any other issue in total. The state of Georgia, through our action and that of the Senate and the governor's signature, have consistently, over that period of time, methodically expanded the ability to allow us to go after those who have harmed children, whether it be obviously going forward. It's wide open on the criminal side. There is no statute of limitations on going after that. We retrospectively cannot do that on the criminal side going backwards. But on the civil side, we have, I'll say, made it very easy going forward to pursue a civil case against somebody. And the thing that we have taken the most time with is what do we do going backwards? Everybody at this table understands the concept of a statute of limitations. It is something that is embedded in our law forever, as long back as we can remember. The purpose of it is to adjudicate cases closer rather than later to the time that they happen, because we all know the longer you wait, quite often the further problems are created. However, in this situation with the sexual molestation of children, there has been testimony, and we have all heard of the concept, and it is debated to the extent that it is prevalent, but I believe it is there to some extent, that there is a suppression quite often of what happened to you as a child, and it comes out later in life. So we have used that as a reason to do something that we normally do not do, and that is change our law as to how it affects people a long time ago and something that may have been happened. We did that to a great extent against individuals who perpetrated actions against children. We have done that to a much lesser extent against entities, and that is what we have been debating with Representative Clark's bill and others that have come before us. What you have before you today in this substitute is, for the first time, I believe, a look-back period to go against entities. It is a measured approach like we have taken before in the past. My assumption will be that the opponents that are concerned about us violating our concept of statute of limitations and their purpose will not be happy with it. My suspicion is that those who have been proponents of this will think it does not go far enough. But I give it to you as consideration as a measured approach forward. And at this time, I'd like to walk you through what it is, and then we will answer questions. I do not intend to have a long debate because, as members of the subcommittee know that I pointed earlier, this will probably be, I don't know, the fourth hearing on this bill that we've had, and those previous hearings have been wide open for anybody to testify that it wants to. But at the state where we are now in the legislative session, the chair intends to move through this, but of course take questions and comments from the members of the committee. If you will look at the bill that you have in front of you, I will tell you one mistake that the chair is going to go ahead and correct now. If you'll turn to line 83 of the bill, there is a misspelling. It's not an ad litem notice, it's an anti-litem notice. Obviously, the chair will ask for a motion at some point, but for the purposes of moving through this, is there any objection that we correct that spelling? Hearing none, that change is made to the draft you have in front of you. Now, if you'll go back to the beginning of the bill. As I mentioned before, there has been a good bit of discussion on about the idea that sometimes the realization of when something occurs that happened to you early on in this area doesn't come on until later in life. If you look on line 20, the current law says that 2 years after realization of something having occurred to you, you can bring an action. That has changed to 4 years, as you can see right there. That's one of the changes I want to note for you. If you will now look over on the second page on line 31, beginning there with that section, notwithstanding the normal statute of limitation, that's that code section which is referred to there, on or after July the 1st, 2020, in other words, cases going forward, a plaintiff who is between the ages of 23 and 38 years old may bring a civil action for recovery of damages suffered as a result of childhood sexual abuse. So in other words, no matter when the realization occurred, even if it occurred at 18, we're extending the age 15 years from 23 to 38 to allow you to bring that claim. And that's notwithstanding when you realized it. That's just stretching it out further, realizing the difficulty of quite often individuals having to bring this forward. That's another significant change you will see right there. Now, I'll bring you down to the meat of the subject on line 55. This is where, for the first time, as I mentioned, we are going to be able to go backwards in time and revive a claim potentially against an entity. And now I want to describe that to you. If you look on line 60, you will see that the look-back period is 1 year, for a period of 1 year. That is similar to what we have done in the past. When we first started opening up the look-back periods, beginning July the 1st, 2020, there'll be the 1 year look-back period. If you will go over to the next page, page 3, you will see how that claim could move forward. The standard of being able to go against an entity that has to be met is on line 66. We have had a lot of testimony through this process that although we are cautious about how we change the law and make things retroactive, there are certain situations which have been uncovered which were pretty obvious that something not only went wrong but could have been covered up intentionally. Almost, as I would say, a fraud standard, in that somebody did something intentionally and tried to hide it from people and didn't do anything about it. That section right there, lines 66 through 72, allows for this look-back period, and I'll read from line 68, intentionally allowed that abuse to continue, or, and then starting on line 69, the important words there are on line 71, intentionally or fraudulently harbored, concealed, or withheld information resulting in the plaintiff's injury. So those are the standards that you have right there for the look-back period. Part of what I wanted to do is we all are aware that the Boy Scouts have declared bankruptcy. There was discussions in these previous committee hearings that our plaintiffs in Georgia would be at a disadvantage when the bankruptcy court lined up decisions of which state had the laws which allowed these type claims, because if Georgia didn't, they would be at the back of the line, so to speak, the end of the funds available to compensate them. We have been told that there is significant evidence in some of those cases dealing with information written down, notes, that something bad happened and proper action wasn't taken. This allows you to go back in those situations where it's clear, in my opinion. Now, on line 73 there, you will see that we also put a limit on how far back we're going to look. There has been discussion in this committee room, and to Representative Clark's credit, he brought this idea to us first of all. There has been testimony that we used to look at how we dealt with this action differently than we do now going forward. Now we know that quite often these kind of people cannot be rehabilitated. We know that you can't help them and then put them back around children again, or it is a temptation most cannot fight against. But we really started realizing this in society, and this gets to when we start holding people responsible because they should have known better. Representative Clark said 1973 is when we first started incorporating mandatory reporting requirements in the state. Upon further investigation and discussing with him and having people look into it for me, yes, there were some that started then, but when they really kicked in was 1988, about 32 years ago, when we first started realizing and putting into law, you better do something about this. You mandatorily have to report abuses against children. That's where that 1988, July the 1st, comes from and gives a 32-year look-back window to go backwards. The standard of proof, once you get into the evidentiary part of the case, is that on line 77, a clear and convincing standard. Once again, because we're doing away with our statute of limitations, a standard that is higher but should be good enough when it is obvious that something went wrong, as has been described in this committee. And lastly, on line 81, as you have known that we put in our first bills on this issue, we didn't care if the institution was public or private. Whatever laws that we opened up, it was everybody that was supposed to protect children or had them in their custody. That public part was not near as meaningful, almost meaningless, I would say, because we did not deal with the issue, whether intentionally or unintentionally. Unintentionally, I think, because we were trying to deal with so much. It didn't waive sovereign immunity. So what you have there in section line 81 to 83 is making the part against public entities real, so to speak, whereas in previous, although we said public, it meant nothing because of the fact we didn't waive sovereign immunity. So members of the committee, that is a walkthrough of the bill. Representative Clark, if you have any comments you would like to make before I open up for questions, the chair would be happy to hear from you.
Mr. Chairman, committee, I want to thank everybody for taking so much time to work on this. And Mr. Chairman, a lot of meetings with you and discussion. I think, you know, from the very beginning when we met in the fall and had discussion, my intent with this legislation is to pass something that would allow justice to be served, that had teeth in it, but not causing any unintended consequences to people that weren't necessarily at fault. And I think through this substitute, I think you've addressed a lot of those concerns. And I know, like you said, the people that are for the bill are probably not happy, and the people that are opposed to the bill are probably still not happy. And I've been informed through my 6 years here that when you make everybody unhappy, it's probably a good piece of legislation. So, Mr. Chairman, thank you for your work, and I appreciate all your help in getting this substitute brought to us today.
Representative Wilson, is that you?
Me.
Okay. Oh, Representative Reeves.
Thank you, Mr. Chairman. For a little bit of historical context for the committee, I don't remember if it was 2 or 3 years ago, but this bill came through Judiciary Non-Civil in its last form, and it came through the subcommittee that I chaired. And we shepherded this bill through, and it did pass the House. It didn't make it across the ultimate finish line, but for a little bit of historical context, first of all, what you said just now at the end is exactly right. This was one of those bills where nobody was happy, and I can empathize with you on all of that. What we wrestled with several years ago on this was the concept of fraud and why a person couldn't move forward on just a generic fraud claim. And the reason why, succinctly stated, is that fraud, one of the elements of fraud, requires detrimental reliance on something that essentially harmed you. And in the case where there was a cover-up of abuse, you can't detrimentally rely on what you don't know. And so what we wrestled with years ago was figuring out how to carve or form a new version of fraud that could account for these specific situations. And so a lot of this is familiar with what we did 2 years ago, but the main difference is in dealing with the look-back period, in the bill that we got out a few years ago, there was no time frame. There wasn't a line drawn, essentially. And drawing the line, obviously, anytime we draw a line, there are those on one side and those on the other, and that creates frustration, and it means that we don't account for everything. But I also think that from a legal perspective and from a a jurisprudence perspective, I never was when we look at statute of limitations and what they stand for and how, and their presence in the law. There was a slight bit of uncomfort with an unlimited look back, even though for a lot of folks that's the only way that they would be able to achieve justice. And as the bill traveled across to the other side of the Capitol, that concept was one of the concepts that was, I guess, looked at as flawed in this. And I applaud you for putting reasoning together in figuring out a place to draw a line that was based in logic as far as the mandatory reporting requirements that came in 1988. And so I appreciate that, and I'm having flashbacks sitting here reading through this bill, but thank you, Representative Clark.
Thank you.
Is that Ms. Silcox?
Yes, this is. Hello. Thank you, Mr. Chairman. I am just seeing, this substitute for the first time today, but I have some concerns for the cities at lines 81 through 83, waiving the notice because frequently those notices, of course, allow the government and the harmed person to work out their differences and come to an agreement without expensive litigation. And so I was just curious the purpose for that.
If you don't waive the ante litem notice, it's impossible to bring a claim against a public entity.
Oh,
Because you
okay,
have
so
to
that's
give
required.
it within
Okay.
6 months or 1 year of the occurrence, or you lose your right to bring a claim.
Okay, thank you.
Representative Walensky?
Thank you, Chair. Thanks for removing or adjusting the part that I was concerned with at the last meeting. It looks definitely cleaned up. Line 7980, it says unincorporated association. Is the reason we don't do corporated because that's the structure of a corporation and it's already
The
takes
idea
into
behind that
consideration?
was in a previous version that we passed through this legislature when we allowed the look back against individuals. You do have some churches that are not incorporated. And the idea was that we would go after an entity, but we would not go after an individual that was not around when the event occurred. So if you have an unincorporated entity, association, you probably have a church where it is owned by a bunch of people, and we would make them individually liable for something that happened 32 years ago, potentially. That's the idea there.
Thanks, Chair. I was asking, but do we not include corporated as well because through the corporation status you can't already? Is that why we don't include corporated?
This is the
also?
first time you can go against an incorporated entity because it has a look back against entities.
Thank you,
In the
Chair.
past, we never have been able to do that.
Thanks.
Mr. Welch?
I'd like to make a motion at the appropriate time, Mr. Chairman.
The chair is going to allow the rest of the members of the committee to be concise with your comments, but I will move to that fairly quickly. Number 14, is that you, Mr. Dryer?
Thank you, Mr. Chair, and thank you, Representative, for bringing this bill. It's great. Victims need to be heard, and that's what you've done. I think that's one of the most important things, and also, obviously, we want to deter future behavior. Mr. Chair, with this, I'm looking at the lines 81 through 83, and it says for the purposes of the subsection. I'm having a little trouble figuring out which subsection it
That
all
would be the one
applies
that
to.
allows a look back to entities.
A look back. Okay.
Yeah.
But, Mr. Chairman, do we need a waiver of sovereign and government immunity for currently occurring sexual abuse and assault?
No.
Some of us would like that, but I understand. Thank you.
I think that's a fair issue to discuss, but I don't want to do that in this bill.
Okay.
Mr. Abstration.
Thank you, Mr. Chairman. This is really a question to the chair or to the other members of the committee who might be able to answer it. But familiar with a concept a few years ago where we had members of a board of a corporation who were potential defendants for liability purposes. I see that, of course, it's available to the incorporated entity, but would that include also members of the board of directors of that entity in their individual capacity?
I don't believe it would.
Okay.
Yeah.
But on line 65, it would potentially include an estate of the accused.
I think you have to bring the claim against a. Would an estate be described as it would be an entity?
Well, I'm thinking more of the definition of person is the individual alleged to have committed the act, and then person is.
I don't think an estate is a person. First of all,
Okay.
an entity would have to be an institution, an agency, a firm, a business corporation, or other public or private legal organization. I don't think an estate would fall under that definition either.
I've had a constituent who has sent members to every member of the General Assembly, I believe, on this issue, has courageously shared her story, and I just appreciate the chair and sponsors' work on this issue, and appreciate you answering my questions.
Thank you. Mr. Mulcahy. Ms. Mulcahy is with the Catholic Church. Although he wants to help people that have been resolved, or have been affected by these problems, he probably thinks, just move over a little bit, he probably thinks it's a little unfair, us allowing you to go against the entity for so far back. Am I correct?
That would be correct, Mr. Chairman.
Can you be more concise in that?
You're taking it back 30-some years. We don't always have records going back that far. And in our case, all of the priests who have been accused, and we have been willing to put the names out in the public on the website of every priest we know of who has committed child abuse in the state of Georgia. Other people don't do that, but we've done that. It goes back to that time. All of the priests, with maybe one or two, are now dead. So we have no evidence to bring, and that becomes a problem for us.
But if there are notes or records, that would be available.
If there are.
And that's what this bill reaches to.
Yeah.
Thank you. We appreciate you
there
being
are.
here today.
All right. Thank you, Mr.
Mhm.
Chairman. And thank you for the other times you've allowed us to speak.
Absolutely. And that is why I'm asking everyone to be brief and concise today, because we have had hours and hours of hearing on this. Mr. Patel and Emily Hurst, please come forward. You want to warn us of how dangerous this could be to our local governments, because it opens up claims going backwards. And you wish you were not included, and I understand that. What else would you like to tell us? Although you are in favor of protecting children and looking for a reasonable way to do that.
You read my mind.
Concise is what I'm looking for today.
That's absolutely true, Chairman. Thank you, members of the board, Mr. Chairman.
I normally say counselor, but I've met you before and I say barrister.
That's very true.
Correct.
Thank
you
you
can tell
very
by her
much.
accent.
Yes, my name's Emily Hurst. I'm with the Georgia Municipal Association. We completely appreciate the laudable nature of the aims of this bill, and we understand that the author has tried to find a balance between the interests of the victims and entities in this case. We just feel that that balance isn't quite there yet. We have spoken with the author, and we appreciate that he's trying to find that balance, and we'd certainly be more than happy to continue talking with the author. The specific areas that we're concerned about in this current version is the anti-litem notice, and we understand that the way that anti-litem notices currently work, as you correctly said, would prevent anything that happened more than 6 months ago, or for counties a year ago, from being able to be brought.
Going forward, that wouldn't be waived, it's just going backwards.
Right, but maybe there's some other type of notice that might be possible.
Well, then what I will do is that I will be, and I'm sure Mr. Clark would be happy if you want to come up with some language, there will be other opportunities to amend this, whether it be in rules or on the floor, and I'll consider that.
Excellent. So that maybe a settlement could be possible.
Absolutely.
Thank you.
Thank
you
you.
very much.
Appreciate y'all being here today. All right, the last is Mark B. Behrens. It doesn't look like Behrens, but it is Behrens.
That's right.
Mr. Behrens is with the American Tort Reform Association. He gave us some pretty good pointers on the previous bills that we had as far as functionally whether or not they worked or not, but you also want to protect children, understand the balance we're trying to strike, and you think we're probably going back a little too far, and we're opening, changing statute of limitations, which previous people have depended on.
Yes. You know, I'm reminded of the Bob Dylan song, "You don't need a weatherman to know which way the wind blows," and I see the momentum today, but we're still strongly opposed to a bill that's got reviver in it for the reasons I talked about the other day, the impossibility of being able to defend these cases, the unfair trials that are set up, and also the staggering costs that I think you'll see on entities in Georgia. And I'm not going to repeat all of that. The one piece of new information I wanted to bring to your attention is to look at the states. For those that are being told that everybody's doing a reviver, it's just not true. There were a number of states that did revivers last year, probably not states that for the most part are a cultural fit with Georgia. They include New York, New Jersey, California, Vermont. Bernie Sanders probably did really well in those states. North Carolina is probably the one state that did a reviver that is sort of a cultural fit for Georgia. But when you look at the states that did prospective legislation, rejected revivers, last year they included Alabama, Illinois, Pennsylvania, Tennessee, and Texas. So a lot of your sister states and states that are probably more of a cultural fit are not doing this. So this is overreaching. We appreciate what you're trying to do, but it isn't going to reduce the impacts on the entities. And
Thank you for being here today. We appreciate you. Chair recognizes Chairman Welch for a motion.
Mr. Chairman, I make a motion for due pass on LC 412494S, which is the substitute House Bill 479.
Is there a second? Any discussion? Hearing none, the chair calls the question. All those in favor, please indicate by saying aye.
Aye.
Did you press your button? I'm sorry. Did I miss you? Well, we did that when we started. I asked if there was any objection to go ahead and making that change. Yeah, no, I appreciate you catching us on that. I didn't see any lights, that's why I didn't look over at you. All those in favor, please indicate by saying aye.
Aye.
Any opposed? The bill moves to rules. Thank you, Mr. Clark. Appreciate your hard work. Earlier last week, the chair put on for a hearing House Bill 828, which was Representative Ron Stevens' bill. Representative Stevens, of course, lost his father and was not able to be here today due to the funeral, as I understand it. Representative Gordon, are you in the room? You want to come present for Representative Stevens? Please come forward. The chair intends to have a hearing on this bill today only, but we'd be happy to hear from you, and I thank you for being here because I know we all know our Representative Stevens couldn't be here.
Yeah.
Yeah.
Thank you, Mr. Chairman.
And I will tell you, if Representative Stevens wants to come before the committee at a later date and also speak upon this, the chair will have another hearing at a later date.
I'm not surprised. Representative Stevens has a heart of gold, and even in this time of mourning, he's still thinking about the state of Georgia.
Proceed.
I do have Dr. Jordan, who's kind of going to accompany me, Mr. Chair, and members of the committee. I don't have a current copy of the bill. I'm sorry.
Pull that microphone a little closer to you right there.
Oh, thank you.
And Representative Gordon, pull that microphone a little closer to you right there.
Is this any better?
Yeah.
Okay.
If you have someone you want to sit with you, that's fine. Come on up here and sit beside Representative Gordon.
Members of the committee, I bring House Bill 828. It is called the Restroom Access Act, and it's a bill that Chairman Stevens has been working on for probably, I think, a little bit over 2 years now. What it does is everybody hearing me? Okay.
You can back up just a little bit. You got to get the angle just right on that thing. Here, wait, pull the other one closer to you, Representative Gordon. That one might work better. I think,
Is this any better?
Yeah. Do you need to switch seats, or are you okay there?
Yeah, maybe let's switch seats.
Technology is a great thing when it works.
All right.
Go ahead, Representative.
Okay. Folks, we know this is a hearing, but just wanted to kind of color a little bit on what the bill does. It allows for folks who have a diagnosis of Crohn's disease or colitis access to restrooms that are currently marked as employee only. And these are members of the IBD family as it relates to
We were trying to fix that mic, Representative Gordon. Sorry to interrupt you there.
That's okay.
There we go. I think the evidently my degree from Georgia Tech tells me that has something to do with making it work. You go ahead.
Again, this is a bill that Chairman Stevens has been working on for, I think, a little bit more than 2 years now. The impetus was started with a constituent that I've kind of adopted, and that is in his district, named Mrs. Christy Edinfeld. And the two of them have kind of diligently been talking about this legislation. I think they've even put it before members of the committee in the past, and even talked to Chairman Cooper, as it does have a healthcare component to it. One of the main, I think, concerns to be addressed by Chairman Cooper was component where they thought that folks could be dishonest just to have the ability to use the bathroom and not necessarily have one of these diagnoses. So a card was thought about that could come from the Crohn's and Colitis Association, signed off by that person's or that patient's individual health professional.
Almost like a handicap sticker type situation.
Correct. To not only let them know that they are a valid designee for this chronic illness, but what the illness is, so that the business owner or person of the business can know directly why they need to use the employee bathroom.
To your knowledge, representatives, are there any programs around the nation? Well, let me just back up. Are there any? And I know you're subbing for Representative Stevens today, so I understand this. Your witness. Why don't we go ahead and introduce her? She may know some more about this. Tell us who you are.
Dr. Ariel Jordan. Oh, I'm sorry.
Dr.
Hello,
Jordan.
I'm Ariel Jordan. I am a third-year medical.
Pull them closer to you.
Hello, can you hear me?
Yeah, that's
Okay.
better.
I am Ariel Jordan. I am a third-year medical student at Morehouse School of Medicine.
Okay, and so I want to bring you in on this. Are there any states that currently allow this? Do you
Yes.
know any of them?
There are 17 other states.
17 other states.
The closest to us would be Kentucky and Tennessee. Both have this bill.
And
They both
basically,
have
you have a card, almost like I'll call a handicap sticker for a car.
Yes.
You show that to the establishment that would otherwise not have a public restroom,
Yes.
and the indication is for them to allow you to use your restroom.
Yes, it would
Okay.
explain the person's medical condition, and it would have a signature from their physician. So that you all the person at the store would know that they have permission, they have this condition, it's signed off by a physician, and so you would know, the person would know that they have this. And that's another issue that we were running into, was people didn't know what these conditions were, and so the card would also explain what this is. So it doesn't seem like it's something that someone made up. It's all documented there with their physician's signature.
Okay, all right.
Mr. Chair, currently
Yeah,
there are about
Mr.
3.1.
Gordon.
Oh, I'm sorry.
No, you go ahead.
I was just going to say, currently there are about 3.1 million Americans that suffer from one of these two diagnoses, and I think Dr. Jordan even has some facts that are more specific to Georgia. One of the main concerns that Chairman Cooper had, along with Chairman Stevens, was that pharmacies be exempted, especially some of the smaller local ones, because the bathroom area can be sometime a close proximity to prescription medication. So there is language, I believe, starting in line 31 that speaks to that.
And I wonder, and that's one example. I wonder if through these other states there are other examples. I know it has to be a retail establishment, so it's a place that is inviting people in anyway.
Sure.
But my suspicion is that there, like a pharmacy, that there might be some other entities that we haven't thought of that may fall into that category. But that's why we're having the hearing, to begin to introduce this to people and to think about it. We do have some questions if y'all will take, is that Representative Dreyer?
Thank you, Mr. Chair. My dad suffers from Crohn's, so I just wanted to thank you for bringing this bill, and thank you for thinking about people that might not otherwise have a voice here and offering a solution.
Thank you.
Do you mind if I ask you a question about that? Yeah. So he I guess has run into this issue before, possibly.
Yeah, it can. Yes, it can be. You can. I can't remember a specific instance, Mr. Chair, but you can see how this could be a pretty urgent situation.
Living with a fear constantly that you're going to need a facility's not available. I
Yes.
suspect,
Yes.
Yeah, absolutely. Representative Silcox? Is that you? Or was that Representative Walensky? Well, let me go to Representative Walensky, and then we'll get you next, Representative Brew.
Thank you, Chair. Thanks for bringing this bill. It's a great bill. I have friends who
Mr.
suffer
Wright.
from both Crohn's and colitis, and so this is very important. Line 36. Why is it 3 or more employees? Why not 2? You know, if they're at Subway and there's 2 folks. I just wonder, I'm sure there was discussion, but why 3 instead of 2?
I'm going to venture a guess, and y'all can tell me that if someone has to escort someone back to the facility, someone else has got to run the front office, so to speak, the front shop. I assume that's what
I
the
think
balance
that's
is
a
trying to
Good
strike.
question, Mr. Representative and Mr. Chairman. I think that's a plausible.
If there's a one-person shop and he's
Sure.
got to go and lock something and leave the store uncovered,
Mhm.
that may not be something we want to push someone into.
And
Try to be
also-
reasonable.
Right.
But I was saying, why not go down to 2 instead of 3 on line 36? But I was just wondering if that was...
That's a fair question.
Yeah, that was all. And then on line 17, is there a reason that we're doing ulcerative colitis and not just diagnosed colitis?
Yeah, so ulcerative colitis falls in with Crohn's disease as a specific, so the two of those together make up a specific diagnosis of inflammatory bowel disease. And so there are different types of colitis, and we have a GI doctor here who is going to get more into that.
Okay.
But these two together make up a specific condition that causes something called flares, which causes abdominal pain and the imminent need to defecate. And so that was why we were that particular one, because there are other forms of colitis, but not all of them cause these particular symptoms.
Thank you so much for explaining. Thank you, Chair.
Representative Bruce.
I applaud the effort too, but I'm just curious as to why the limitation on just these 2 illnesses. And I know these you're talking about having to, go to the bathroom, but there's other things too that cause you to have to go to the bathroom.
Yes, so actually I can attest. So it's not just those 2 conditions. We just have examples of those, but it also includes irritable bowel syndrome.
On line 17, 18, and 19, it includes some other
patients
stuff.
who have an ostomy device, or patients in general that have a condition that requires immediate access to a toilet facility.
Sometimes it's your bowels, sometimes you just got to get the water out there too. So I guess
A urinary problem.
Yeah, I guess I'm just trying to see whether or not it would be applicable in that instance, and I guess I'm sensitive to it because I know people who are taking certain kind of treatments for prostate issues and things like that. That you got to go.
Yeah.
And so I'm just wondering if this would be applicable. It doesn't sound like it right now, but it seems like it should be applicable to any. If you got to go, you got to go.
That's another good question, Doctor. I don't know if you obviously are knowledgeable about this. Are there any other states around the nation that apply this to a urinary condition?
Well, some states do include pregnancy, so that is yes, other conditions can be included in this, and so it can be extended to other conditions. The bill gives that leeway. It's basically and we're listing these out because this is the language that other bills have used, but other medical conditions that require immediate access to a bathroom. So a patient with heart failure that's taking water pills,
Sure.
They could definitely fall in this category as well.
See, is that Representative Jones?
Thank you, Mr. Chairman. I'll make this quick since it's a hearing only. So thank you very much for bringing this. I echo many of the comments made by my colleagues. Given that when we're outside of session, I'm on a Delta airplane just about every week, I have seen service animals perverted to no end. And I used to think that healthcare providers would only sign off on those if it was legitimate. So I would ask that when you and Chairman Stevens get together and think about what some modifications could be. I know on line 60, we talk about any person who violates this chapter shall be guilty of a misdemeanor. I know enforcement against an out-of-state doctor or an out-of-state healthcare provider may be difficult, but maybe there's a creative solution so that we encourage healthcare providers to do this for bona fide reasons and not just because they set up a website and basically provided for that card, because I do consider it a true issue. I just want to make sure the people who need it get it, and let's just say those that just want to be able to use a facility when they want to, let's just say they need to stand in line. Thank you.
All righty, we have one other person signed up.
We have a few others. I'm sorry, they came a little bit late.
Well, I tell you what, you're in charge here. You and Representative Gordon. You pick two that you want to come forward and talk to us today, and we'll be happy to hear from them.
We'd like to have a patient who
Come on
actually
up.
suffers
Come
with
on
this
up,
condition.
Representative Gordon. If you want to slide
Sure.
over
Sure, let's speak.
and let this young lady sit right there, we'd be happy to hear from her. Dr. Jordan, you're Ariel Jordan, right? Just want to make sure I didn't cross off the wrong person here on the list that already spoken. And I do have, is that Carrie Perkins?
Yes.
Is that you?
Yes.
Okay, well, you were on my list. Okay, good. I'm sorry I didn't know who you were. Please introduce yourself. And
My name is Carrie Perkins. I have Crohn's disease.
yes, ma'am. Thanks for coming today. Go ahead.
You're welcome. And I've been to certain bathrooms in Georgia, and they wouldn't let me use the bathroom. So I end up had to have changeable clothes and end up using the bathroom myself. And it's embarrassing. So we definitely need a bathroom to use.
We appreciate you coming today.
You're
Thank you
welcome.
very much for putting, although we have some people that have committee members who've mentioned that they have family members that suffer from this, and maybe some committee members, but you also put a face on this for us. So we appreciate you coming
You're
forward
welcome.
today. Thank you.
Uh-huh.
And I like your red and black, even though it says South Carolina.
And thank you.
Thank you so much.
All right. Did you have one other person you wanted to bring up?
Yes,
Mhm.
we have a
Please,
gastroenterologist.
come forward.
Yes.
Mm-hmm. Welcome. Good to see you. Please introduce yourself, and we'll be happy to hear from you.
Hello everyone, my name is Pramod Pantangi. I'm one of a practicing gastroenterologists from Grady Hospital.
Dr. Tell me your last name.
Pantangi.
Dr. Pantangi.
Yes, I'm
Welcome.
a practicing gastroenterologist, and I see patients with inflammatory bowel disease and irritable bowel syndrome almost every day in the practice here, so I kind of know what they're going through. To give you a brief specifics about the burden of this problem in the United States, the numbers keep changing, but approximately at least 1 in every 100 people, almost 3 million people in the United States suffer from various forms of colitis. And more than double those numbers suffer from irritable bowel syndrome. And the numbers are only growing. And majority of these patients have symptoms which includes sudden urge to go to the bathroom for passing a bowel movement, and they consider these as a flare. No matter what medications they are on, and no matter how controlled their symptoms are, there can be flares sometimes. And it's very hard to predict medically when the flare is going to happen. So majority of these patients have significantly lower quality of life when compared to the general population. And these decrease in the quality of life is because sometimes this is fear of social humiliation from the episodes of the stool incontinence in public, which prevents them from leaving home, which ultimately end up, people take sick leave. And there are few cases which have even worse outcomes, claim disability, and seek unemployment, and they just go into a downward spiral from there. So I sincerely think that this Restroom Access bill, if provided it, if it passes into act, it will tremendously help the people in going on with their normal lives and obviously fulfill their regular duties and jobs and all that. So.
And doctor, how long have you been practicing in this area? You said
3 years.
At Grady.
Mm-hmm.
Okay, great.
Yeah, yeah.
The we heard some testimony earlier about, or some questions about urinary tract problems.
Mm-hmm.
Are you familiar with the other?
I deal with primarily gastrointestinal diseases, but
Okay.
I do understand when they say that some of the urinary problems also can fall into this category.
Okay.
I don't usually deal with them, but I can see how these both disorders can be lumped together. Yeah.
Okay, good.
Mm-hmm.
Well, thank you for coming today. We
No
appreciate
problem.
it.
Thanks for considering this bill. Yeah.
Well, and I do want to say again, I kind of referenced it to start with. Representative Stevens had intended
Mhm.
to come to us earlier in the session so we could have some hearings, find out some information, and possibly consider moving the bill.
Mhm.
But for those of you that don't know it, not only did he just lose his father and is at the funeral there, but he
Mhm.
lost his mom also earlier this session.
Oh.
And so he's had quite a difficult time of it, and I completely understand why he
Mhm.
wasn't able to come to earlier meetings and whatnot. And so we would have more time to work on this. But nonetheless, you start somewhere, and this is the beginning, and I appreciate y'all being here today. Thank you so much. Thank you, Representative.
Thank you.
Is it possible to get
Mhm.
Christy Edinfeld's statement entered into the record?
Absolutely,
Yes.
absolutely. Do you have it?
Yes.
Okay,
we have a
sure.
copy for statement.
Okay. Who is this? Whose statement?
Christy Edenfield, that he mentioned, Christy Edenfield.
Is she here?
She's not here
Okay,
today.
she's not here. Okay,
she's
good.
having
I was
Crohn's
going to tell her to
symptoms
come
and-
up, but go ahead. Yeah, absolutely. If you will give it to Bradley, right here, one of our legal externs.
And then we have a really short statement from the Crohn's and Colitis Foundation. They just wanted to say that many inflammatory bowel disease patients have to worry about whether or not they have access to a restroom when in public. The foundation supports and empowers volunteers to be champions of legislation which will allow for an IBD patient's emergency access to an employee-only bathroom. And they wanted that statement entered into the record.
You give that also to Bradley right there, if you would.
Mr. Chair.
Yes, sir.
I heard this testimony in subcommittee.
Yes, sir.
And my thought was, if you go to one of these bathrooms, they won't let you in.
Turn your mic, hit your button there, so.
And they won't let you in. She heard me say it in the subcommittee. Just go. Let the next one in.
We would call that bringing attention to the situation, wouldn't we? Yeah.
Well
Okay.
said.
Thank you. Appreciate y'all being here today. Thank you very much.
Is it possible that we can get a vote today, or is that?
No,
not
ma'am,
possible?
not today.
Okay.
Mhm, yeah.
Thank you.
Which one you want to ask? Dr. Moorhead? Dr. Jordan? Dr. Jordan?
Would you mind providing us with and you can with a list of what other with those urinary tract issues that might also fall within this category that we should consider?
Sure, we can do that.
Okay, thank you.
And also the Georgia data. She also has data on how, we talked about the 3.1 U.S. stats for the Georgia as well, I think.
I submitted that in my statement, unless you would like me to read them to you all.
No, that's fine in the statement. Thank you so much. Appreciate it.
Thank you, committee.
Thank you.
Mr. Chairman, I'd like to go ahead and present for the substitute
1078.
to
And
1078.
I think we're passing that out to the committee members right now, so.
All right, in our previous hearings on this measure, we had some concerns from members of the committee regarding the scope of the fees. And so what you'll have is a substitute that's being passed out here. The previous version applied to all courts in terms of the assessment of the fee. There was a lot of concern by members as to that the extent of the fees are already very high coming into Superior Court and State Court. And so in taking that in consideration, this substitute only affects the magistrate court. And so you'll see that it amends the magistrate court and authorizes the magistrate courts of the state to impose at a maximum a $10 technology fee. And so you'll see that as at lines 12 through 21. And then it will also take that money and will be collected by the clerk of the magistrate court, and then it will be maintained by the governing authority. It creates a, through the chief judge of the Superior Court, a criminal justice information system committee that would be made up of the chief judge of the magistrate court, the judge of the probate court, the judge of the state court, the judge of the Superior Court, the clerk of the Superior Court, and the sheriff. And this committee would be in charge of spending the money that's collected through this magistrate court fee. The technology fee on lines 29 and subsequent would only be a surcharge levied against after a conviction or filing a civil action or filing an affidavit, except for affidavits of indigency. Then finally, the lines 33 through 42 specify the uses in which the money collected could be used. And you'll notice there that there was some discussion. I think Representative Walensky had asked questions about cloud storage. So we added that in there at line 40. You'll see purchase or lease of data storage. Rather than using the term cloud, we went with a more generic terminology. And so you'll also see at line 41, I added there the purchase of local or remote technological support services, because there may be, oftentimes you can get your technology services from a remote provider as opposed to local. So those were some clarifications that we made to this based upon the comments that had come out from committee at our last hearing. And I would like the bill to move forward if at all possible.
So if I may, Chairman Welch, to summarize, and I think you did hit on a lot of the concerns that were brought up in the previous hearing that we had. Two things have to happen for this $10 fee to go into place. First of all, it's only in magistrate court proceedings. And as I started asking questions about this, and others did, magistrate court is the one filing fee that was not raised going on close to 9 years ago, when there was number one, a budget crunch at the state, and an overall review of our filing costs compared to other states in the Southeast. If not, I think in the Southeast it was done.
That's
where we
correct.
found out we were significantly lower. And at that point, the $125 fee was added on, but it was not added on to magistrate court. So that's not one where the increase took place several years ago. The other thing is, it's just not up to the courts in this situation to apply this. First of all, a magistrate court judge would have to authorize the fee, and then the fee would have to be approved by the governing authority of the county, the people that appropriate money to the various courts of the county. Correct. And other county functions. And so there was some discussion in our committee hearing of the problems with putting, and I'll use my words, not words I think that were heard then, but I'll try to summarize, putting courts in the position of trying to figure out how to appropriate money for technology. Now you're putting it back into the hands of the county commission, most likely, who has to appropriate money on a regular basis for all sorts of function, including technology, and in this particularly cyber protections. So is that and of course you made changes on the other part. Representative Walensky brought up the need that what you might need is to purchase storage in the cloud. You've got that in there on line 40, and I think you limited further where it would be applied on lines 29 through 32. Did I miss anything, or is that a pretty good summary?
That's a very good summary, Mr. Chairman.
All right. Representative, is that you, Representative Walensky, number 8?
Yes, thank you, Chair. Just my only question is line 30, conviction. Is that, would this, so a court would say this, I don't know, if somebody's, what is the punishment, or what happens if somebody's convicted, there's a fee and they can't pay the fee?
Yeah, and if my understanding would be that it would be metered out over a probated process.
So it would be part of their probation in a sense?
Yeah.
Okay.
Yeah, so and this would probably be an ordinance violation at the county level.
It would be an ordinance violation typically,
Right.
yes.
Right.
And that makes sure that everybody that could find themselves in magistrate court is all subject to the fee uniformly, not separating just civil actions from criminal, but making sure everybody's chipping in.
Thank you, Chair.
All right. Representative Jones.
Thank you, Chairman Fleming. Chairman Welch, thank you for bringing this bill. Quick question on line 40.
Yep.
I have a little bit of knowledge in this area.
Yes,
Yeah.
I texted you earlier trying to
Yeah.
tap into that knowledge.
My concern, I like lease of data storage.
Yeah.
It's the purchase, because that could imply to a governmental agency that we need to stay in the 1980s and go buy server boxes and place them into a closet that isn't secure. That's just me hypothetically saying that that could occur. We clearly want to encourage them to move into the 2020s. And I just looked up AWS's standard agreement, and it refers to the use of the service like a lease. Our rack space contract is,
AWS?
I'm sorry, Amazon Web Services. And so I would just ask.
I knew that. I was just seeing if anybody else did. Go ahead.
And Chairman Welch, you are by far a better lawyer than I am, but could a removal of purchase or out of 40, would that hurt and just remain with lease of data storage?
Well, I do appreciate your expertise in this area and your progressive viewpoints on how technology can better improve governmental services. The problem that I see is that there are still places that use, physical storage on site, and I know that that creates creates consternation with you. But in order to make this functional throughout the entire state, that's why I have purchase or lease. Now I know your preference would be to push them into the leased data storage, but
Yeah, because in all seriousness, my concern is these companies like AWS, and I'm not sure, I can say Azure from Microsoft, et cetera, to make sure everyone gets a good branding conversation here. But they're up 24/7/365, ensuring there is no breach. Notwithstanding how secure our closets are on the 9th floor of the Floyd building. But at the end of the day, I'm sorry, I don't mean to be sarcastic. This is a serious matter, but I just get concerned that we'll just continue to perpetuate this, and come 2030, we'll still have boxes sitting in closets. And is there anything that we could do to maybe date limit it or something to that effect?
the good news is that you have members from AOC here, the Office of Administration of the Courts, within whose budget we have added some additional funding for security, actually with the Superior Court clerks, Superior Court Counsel. They actually got some funding in the budget to help out with some data security. So I think this is a message that you are sending that they will be listening to and push downward into the Superior Court's systems. And since this is a committee of the whole, I think you'll have good ideas coming from this committee. But I'd really like to lay in that local jurisdiction and let them make the decision.
Okay. Thank you, Chairman Welch.
Representative Wilson.
Thank you, Mr. Chairman. Chairman Welch and I spoke about this last time, but I still have concerns about us adding fees without fully understanding the landscape of what fees are currently being charged in the state. And Mr. Chairman, I don't mean to drag this out any longer, but considering that we have a substitute here, I noticed that we do have some judges in attendance today. I wonder if we might invite them to weigh in on the substitute.
Well, and I do have one witness too, but if you, so why don't we do this? You think about who's out there you want to ask a question to.
Sure.
And you can warn them by texting them if you want to. But while you're doing that, I will ask Rushi Patel and Emily Hurst to come back up. You had signed up. You wave? Okay. All right. I won't tell you what you're going to say this time if you want to come up. Yeah. Okay. You have anybody in particular you'd like to ask?
Well,
Do we have any? Well, you know what, Judge Hambrick and Judge Weaver, there y'all are back there. I've sitting here and gone through 2 bills already and failed to recognize you, and please accept my apologies. I should have done that from the start of the meeting.
Before to hold Representative Welch or someone in contempt for
Yeah.
recognizing me. Does that now apply to you, sir?
No, I recognize. No. I recognize you. Yeah.
It wouldn't be the first time.
Do as I say, not as I do. Yeah. So, absolutely, Judge. Thank you. But Representative Wilson.
If they want to,
absolutely.
I'd
Would y'all
love
like
to
to come
hear them
forward?
weigh in.
Your Honors.
Yes, as a matter of fact, we just had a conference call.
Judge, come up and introduce yourself, please.
My name is Brenda Weaver. I am the Chief Judge in the Appalachian Circuit that consists of Pickens, Fannin, and Gimmer counties. As far as the substitute, certainly we are all in favor of the technology bill. But based upon the way that it is now written, the direction that I got from our judges is that we do not agree that it would only be with the magistrate court. For example, Fannin County is a very small rural county. If we only include magistrate court, it would be years before we would have enough money in the technology fund to do anything that we need to do in terms of cyber insurance, increasing the computers and technology in the courtroom, using video technology in order to hook on, for example, to have our magistrate judge in Fannin County be able to, or the judges and our superior court to be able to handle hearings from the state prison system using the video. So we're not quite sure. I understood what you were saying in terms of going back, just using the magistrate, but for rural counties, and we're the counties who really need this fund in order to have the technology, the amount of money received from magistrate court based upon the number of cases they would have in Fannin County would be very small. And it would take a period of time before it would build up to something that we could actually use to purchase anything.
If I might, Judge, if I may.
Okay, go ahead.
Let me propose to you how the legislature, in my experience, sometimes learns about issues here.
Okay.
We passed this today. We have medium-sized counties to large counties who do benefit from it because they do collect up enough money and they can come in and testify how they have benefited from it. At that time, the legislature has now learned, possibly, of the value of this, and we think about expanding it because smaller counties come in and say, you know what, if we could do this in other courts like the original bill proposed, then it would also help us. So sometimes we have to take baby steps and learn to walk before we run, and there is a hesitancy with adding on fees. So
I understand that.
I would just throw that out there to you is sometimes we call them pilot projects around here, and we name them that. But they are to experiment on how something is done or not done, and then we expand it after that. So I would almost ask you to think of this potentially in that scope. Does that make sense?
I understand that, but also understanding that the counties that would need to be able to use this fund are the very counties that will not be able to because of the small amounts they'll be receiving in the next couple of years. And in addition, I'm trying to think how the magistrate judge in Fannin County would react to the fact that his court's the only one putting money into it, but the committee is chaired by the chief judge of the Superior Court. Sometimes I see some potential problems.
Is there a committee approach here? That's in the decision of how to utilize it.
Yes.
But the county authority would have to approve
That's correct.
the appropriation.
They still have to approve by resolution and authorize it.
Yeah, okay, okay. Fair question, Judge. Fair question. Thank you.
So your preference would be that the technology fee be applied to all level of courts and
yes,
as opposed
even
to
if
just
you
magistrate.
even if you limit the amount to $5 as opposed to 10, if we let each level of courts, superior, of course in our circuit we don't have any state courts, so we have a superior court, a probate court, and a magistrate court. Most of the traffic, of course, is in the probate court, where a lot of the fines are actually given for traffic violations. In our superior court, we also handle traffic, including DUIs. And as you were asking that question, let's say that a DUI, I enter a plea of guilty to a DUI, I'm fined $1,000. So that would be a $1,000 fine. That would be a $500 date fine fee. That would be a $100 jail fee. A $50 what we call surcharge one, $100 surcharge two, a $25 crime lab fee, a $50 victim assistance program fee, a $150 Joshua Love fee, a $5 library fee, a $100 sit fee. So there are a lot of fines and fees, and we understand that. Sometimes I end that by saying in a partridge in a pear tree, because certainly DUIs do have a lot of fines. A lot more surcharges are actually attached to traffic violations than to like a $1,000 fine on a criminal case in Superior State Court. They do not carry all of those other additional surcharges that's been assessed, particularly in DUIs and other traffic violations of that nature, which I bet the judge in probate court could talk about. There's a lot of surcharges in traffic violations for whatever reason. But
so I guess the ultimate question, if I may, Judge, is that this crossover day is tomorrow. this probably will be our last chance to open up this discussion to actual legislation and begin a process. So the question would be, should we pass this now and let it be, albeit a flawed beginning, but a beginning that we can add upon later, or should we not?
Boy, that you just put me on the spot.
Well, it's a spot
Certainly.
it's a spot that we're on right now.
Well, I certainly would not want to deny the larger counties of having the ability to use this fund to do some things that need to be done. I just really wish you guys would reconsider and not limit it. Even if you said counties under a certain level would include Superior Court, because it's not going to do the things that we need to do with this fund if we only limit it to magistrate court in the smaller counties.
Well said.
It's just not going to do that.
Thank you.
But whatever you do, we appreciate, but maybe we could come back next year and try again. But I just wanted to make sure that it was made known that the Council of Superior Court judges
ma'am.
would again ask you to reconsider and include all other levels of courts.
And that's exactly what we want to know, what everybody thinks, and we appreciate you bringing that to us today. But
Thank
I think
you.
Representative Wilson had another question he wanted to
Yes,
ask.
sir.
Judge Weaver, are the fees that you mentioned, are those particular to, are they specific to the conviction, or are they specific to
Conviction.
the court?
The conviction, well, it's the conviction, though. The same surcharges that you would have in a DUI and probate court, you would have in Superior or State Court.
Okay.
And you understand most of those surcharges, they go to the state. The county gets to keep the date fund and the law library fund and some of the other things that, and there's some other things taken out of the fund that we don't even call a surcharge because they're taken out as a part of a different laws when under the fine itself. But most of the surcharges that have been imposed go to other entities. They do not stay within the county. The date fund, the law library fund, and the jail fund. All the others, I think, go to other state entities.
Thank you.
Any other questions for Judge Weaver? Judge, we appreciate you being
Thank
here.
you.
Thank you so much. We appreciate you coming up rather than Judge Hamrick also. we love Judge Hamrick. He used to be one of our colleagues, and we appreciate him being here too. Thank you, Judge. All right. Any other? Let me see. Do I have anyone else signed up on House Bill? I don't believe I do. Do I? Well, let's see. Hold on. Yeah, that's correct. All right. Any other questions from the author? For the author, from members of the committee? All right. Well, the chair will bring the bill back to the committee, and now, if anyone desires, would be the appropriate time for a motion.
Move to pass.
There's a motion to pass. Is there a second?
Second.
There's a second. Discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? No. You move to rules.
Thank you.
All right.
Thank you, members of the committee.
All right. Chairman Welch, you have the last bill of the day, and that would be House Bill 484.
We've had 4 hearings on this particular piece of legislation, 3 in subcommittee and then 1 in full committee. 484 is an attempt to try to rein in unscrupulous medical funders and their associates, if you will. I'm not going to go back through all the litany, but the bottom line is that there is an entire private sector funding network that is tied into the recovery of cases based upon the injury of a personal injury case, and those that are receiving the revenue are the funding companies that purchase the liens or accounts from the doctors, and then are betting on the differential, the award of judgment thereafter to make their profits. And in doing so, these contracts can be very market-based driven and very fair. But there are also others that are not, and that place the actual injured party in a posture of being of even having actions brought against them for collection, and also may place the doctor in a position where he or she is compromising doctor-patient relationships, as well as the attorney compromising attorney-client relationships, under those that may choose to act unscrupulously. In that regard, this bill is an attempt to regulate and to put some guardrails around that industry, to protect the consumers, which are ultimately the injured parties that are in the worst possible position, injured, probably unable to work, and in need of medical attention. The committee has heard a good discussion at our last meeting concerning both the regulation of this, seeing the need for the regulation of it, while also being concerned that the scope of the bill goes too far and interferes with the litigation process as it's drafted. And so what I would submit to the committee is, and I would ask for the committee's favorable approval of the substitute to 484, but I would offer to the committee, after discussions with Representative Walensky, that lines 36 through 48 be deleted if it is to move.
36.
I heard my name, that's why.
Well, in discussions with you, that your concerns about how this medical funding issue might affect the litigation process, I was going to ask that the committee approve the bill as is, but strike lines 36 through 48. That would eliminate the mandatory discoverability of these contracts. And I think that was causing concern for certain members of the committee. And that's my presentation, Mr. Chairman. I'll be happy to take questions about it.
Okay. There are questions, and we have several signed up to speak. Chairman Welch has indicated that he intends to make a motion when the appropriate time comes to get rid of lines 36 through 48. And if I understand that correctly, and Chairman Welch, you chime in here, that is the portion which got the most attention. That is the portion which required to make possibly discoverable, not necessarily admissible, evidence of the amount paid for actual medical treatment. Is that correct?
That is correct.
Okay.
And it's also the aspect of it that I think was causing the medical funding industry, the ones that are good, that are purportedly good actors, concerned that it would A, compromise their marketability, and B, also even silence the market here in the state of Georgia.
So what I would like for the committee to discuss first, because I do not want us to move ahead with a bill that we're actually not going to even consider, or portions of a bill we're not going to consider. In other words, spend a lot of time talking about something that's coming out of the bill. So what I want to do first is I want the committee to discuss, and I want to get your feel for whether or not you're going to support Chairman Welch in his motion to take out that piece, which once again has drawn the most attention. Do the committee members understand what I'm asking you now? I'm trying to figure out what bill that we're going to discuss here, because if we're going to support taking that portion out, we're discussing a different bill pretty much than we are the one that is in whole in front of you. So I'd like for you to focus on that part first, and then of course we'll have a full discussion and have witnesses on the other parts of the bill. You want to, well, let me see what Representative Bruce, press your button down there. Press your button and let me recognize you and go ahead and ask a question.
At the last meeting, did you ask them to go and work together and come up with
I asked
something?
Yes, I did.
And that we would address that. Did that happen at all?
Well, what did happen, and I will let Representative Walensky speak next, and Representative Welch can chime in here now, is that there were several discussions about the possibility of doing something. The prior discussions I were involved in also were that the consumer protection portion of this, or should I say consumer awareness portions of this, there was not as much controversy or dissent about, and would it be good to move ahead with those even if we couldn't in this period of time figure out how to solve the underlying problem. So does that help answer your question? Bring your microphone over to you.
Because it seemed like that would be the best thing. We getting calls from both sides, it would be great if they could just go.
The chair,
talk.
the chair agrees with you, and I would think that that's going to be a discussion for a future time. Obviously, if the bill moves out of this committee today and out of the House, and the two sides can agree upon something, we just bought ourselves almost another 3 weeks to possibly do something, because as you know, the process moves, and there are other opportunities to amend bills at later times. So let's see.
May I comment?
Yeah, please, Representative Wilson. I'll go to you, Representative
Yes,
Lewis.
and to be transparent, everyone that's interested in the bill has come to see me and discussed the bill with me on multiple occasions. And as we discussed, and as I presented at the last meeting and in our final subcommittee meeting, there are other measures that are moving around this Capitol that place people in postures where they cannot make any changes or submit anything at this time, because there are things that are moving possibly in this direction. And so that has compromised their ability to work on specific language in this bill. The second point is that I would like to see this move, because I'd like to force the issue. I mean, to your point, when we move bills here, people start actually, I mean, Chairman made it, I made it direct myself. Chairman has made that statement directly as well. The response is, we don't have anything for you at the present time for a variety of reasons. But as bills move in this process and they go forward, individuals start to pay closer attention, because we get closer to making law. The bill that you would have before you, if you were to remove the lines I'm saying, is essentially consumer protection guardrails that we would put for the first time in code for the state of Georgia to help protect those that are the most vulnerable in the process. So I would like to see that go forward, because I'd like to have an affirmative statement that there are certain practices that the state of Georgia will not tolerate with respect to medical funding, taking advantage of any of those injured parties.
Representative Lewinsky.
Chair, can you help me? Am I answering your
Yes, sir.
question? Where am I at in terms of what I'm doing with this?
What I asked
Yeah.
of the committee was to give me your feelings on whether or not you're going to support Representative Welch's motion to strike lines 36 through 48 in the
Yeah.
bill, which would turn it into something, and I'll use the term, less controversial, and most of the discussion centered around whether we like those pieces or not,
Yeah.
and now we're getting rid of them.
Yeah. So
Yes, sir. Go ahead.
it's still my first.
Does that make sense?
Yeah, yeah.
Yeah,
And it's
yeah.
my first term. Hope to
And
serve many.
you're doing well.
Thank you, Chair. Thank you,
Mhm.
Chair. And just so I understand procedurally, if
Yes,
we
sir.
pass anything today and it does pass the House and it goes to the Senate can do anything they want. Will I ever see again to vote on it?
Yes.
Yeah, it can't. If the Senate changes this, it has to come back to the House for consideration. Yeah, the Senate can't pass a bill that's not exactly in the form it would come back in. If this went over to the Senate and they put anything else in or even changed a comma, it has to come back for an agree-disagree.
And that's on the House floor, just an agree-disagree vote.
That is correct.
But no more changes can be made.
No, you can
we disagree.
you can amend it at that point. The bill can be amended at that point.
Okay.
You can disagree, you can agree as amended, and
But if it disagrees and goes to conference, and I'm not a part of the conference, then whatever comes out comes out.
No, the conference committee report still has to be approved by the House and Senate and identical language. The only difference between that stage of the game is that a conference committee report cannot be amended.
Okay. Thank you,
But it
Chair.
still has to pass on an up or down vote. Yeah, does that make sense?
I think so.
Okay. All right, Representative Silcox.
Thank you, Mr. Chairman. I continue to press the point that I do believe that medical fundings serve a very important public policy purpose in our state, because they provide a way for people that are uninsured or underinsured to be covered for their medical expenses. And I am pleased that Chairman Welch wants to delete part of the language, but the bill itself is completely inconsistent with the Lean Act, and I think that I would be happy to pass part of the bill with about 10 amendments. to the language. I've consulted a number of people overnight, and as I said yesterday, or the previous hearing rather, I think that the bill as written is inadequate to address the problem we're trying to solve, and I would be happy to do a study committee on this issue over the summer. I think it is a problem, but I want to solve it the right way because we need to provide coverage for these people that don't have it.
Thank you, Representative.
Thank you.
See, is that Mr. Wilson or Ms. Oliver?
I apologize for being late.
No, you had to be in court. We understand.
I know. Judges, you know.
Present company excluded.
Moving right
That
along.
would be Judge Hambrick. Not
Right.
me.
Yeah, that's right. That'd be Judge Hammer.
Moving right along. As I understand our posture, you, Mr. Welch, want to take out the part that says these documents are discoverable.
Yes.
And leave the parts in the bill to move forward as a consumer protection items. That's what's left of the bill. And one argument in support of that, I think I'm right, tell me if I am, that the 11th Circuit Court of Appeals has already said they're discoverable. There's some
That's correct.
individual state courts that have been on both sides, but the law right now is it is discoverable. So the whole issue for us that we're talking about in a complicated way is what does this vehicle become in the future?
Well, I don't, I want it to be a consumer protection measure, which is the bulk of the bill. But we have spent a lot of time talking about the litigation aspects, and what medical funders have told us is that they don't have a problem with any other aspect of this bill except for it becoming a part of the litigation itself and that exposure that they have in that litigation by requiring that it be discoverable or admitted directly into evidence. We have taken all the collateral source elements out of it, all the evidentiary elements out of it, and cutting it back to the core of just being a consumer protection measure.
Representative Walensky.
Thank you, Chair. Well, I just reviewed what we have left, and it's, it leaves informing the consumer of what they've signed. I think in my experience in 10 years and what we saw, the consumer always signs it. And then we just have a couple of sections relating to, I guess you could call it kickbacks or otherwise. And if we're trying to put guardrails on the industry, I guess my two questions would be, who are the bad actors we're trying to guardrail, and how does this put guardrails around them?
Well, we heard testimony before, so I'm not going to go back through the testimony we've already heard. As to those that are bad actors, we saw the testimony that was driving patients into waiving their own current insurance policies on the speculation of coming out better with better health care providing companies, but those same companies also collecting on the debts that are incurred against those patients. And that's what the other portions of the bill go to, that you cannot pursue a consumer for the debt or the obligation incurred in the medical funding providing. That was an addition that was made. That's at lines 65 and 66. These decisions shouldn't remain solely with the consumer as to settlement. So there shouldn't be any conflict of interest between attorney and client influenced by the medical funder. There shouldn't be any kickbacks, as you mentioned, and then making sure that the patient the victim is adequately informed as to what is incurred and what is going to occur within the contract. That addresses the egregious situations that we heard in subcommittee and that we heard in full committee as well, without getting into the litigation of the matter and presenting those contracts as part of the litigation.
I'll just
go ahead.
One more statement per that. Based on the quick PowerPoint I saw, we never found out if those individuals purposely waived. Were they asked whether they want to waive those reasons they would? And anyways, happy to move forward. Thank you.
Okay. All right. Here's the posture we find ourselves in. The chair does have several people signed up that want to testify. I do intend to hear from them. However, I want us to know what bill we're talking about. At this point, Chairman Welch has said he wants to delete lines 36 through 48. We're going to find out right now if that's going to happen, and then the chair will open the floor back up for discussion. But Ms. Silcox wants to talk before I do that.
Yes.
Go ahead.
If we are going to take up part of the bill,
Mm-hmm.
I would like to try to amend the bill that we're going to take up.
Absolutely. Yeah.
Okay.
In other words, what the chair intends to do right now is
Mhm.
see if there's a do pass motion in a
Okay.
second. If there is, I'm going to allow him to make his amendment to strike the portions he wants, and then we'll have a bill in front of us, and then you can start thinking about your amendments, because
Okay.
I'll come back later and take amendments to the rest of the bill after we hear testimony on the bill that's in front of us. Does
Okay.
that make sense?
Mm-hmm.
Okay. Anybody have any questions about the posture we find ourselves in, or what the chair's intentions are? Okay. All right. Is there a do pass motion?
Do pass motion.
Is there a second? Chair seconds the motion. Okay. Now, Representative Welch, do you have an amendment?
I do. Mr. Chairman, I'd like to move to amend lines, put a period at the end of, instead of the semicolon at line 35, put a period, and then
Right.
strike lines 36 through 48.
All right. That is the motion. Is there discussion? Hearing none. All those in favor of the amendment, please indicate by saying aye.
Aye.
Any opposed? That is done. Now, we have a bill in front of us that I think we can discuss, take testimony on, and then have final consideration. So, are there any other questions from the committee members before we go to the people that want to testify? Okay. Cade Perrin? Kate? Welcome. Good to have you. Please come forward. We'd love to hear from you, and please introduce yourself.
My name's Cade Perrion. I'm a lawyer from Carrollton, Georgia. I'm here on behalf of the Georgia trial lawyers, but also kind of on behalf of West Georgia. Okay, I've been in practice of law for about 15 years. The first 10 years of that practice, as Judge Hamrick can testify to, I spent representing small businesses getting whipped by loss share banks in the Superior Court of Carroll County. Represented many debtors. I've seen the good, the bad, and the ugly of just about every business transaction there is. About 6 years ago, I transitioned my practice to mainly representing personal injury plaintiffs as well as some governmental entities. When I first joined GTLA and started practicing in the personal injury realm, I heard a lot about medical funding. It took me a solid 2 years to figure out exactly what it was. I knew from my time representing debtors in bankruptcy that pre-settlement loans and title loans and such were vehicles to force my clients into Chapter 7 bankruptcy. I had that same view towards medical funding. I thought it was one and the same. My practice is primarily based in Carrollton. I represent people on the western side of Georgia from about Columbus all the way up to Rome. What I found out was when these people were injured in car wrecks and whatnot, they would come to see me and they were not being able to be seen by any kind of medical provider. They were left with what I call the snap, crackle, and pop of the chiropractors for things that were just not going to be chiropractically treated. So I began researching medical funding. And once I began to understand that medical funding is like debt buying, it's the purchase of an accounts receivable. That I've watched every hearing online, and I watched the PowerPoint the other day. There are no interest rates and things of that nature when I talk about medical funding, okay? What I do know is that I have clients that are being seen by Carrollton Orthopedic now, who before that had nobody that would see them except for the fly-by-night medical provider who holds their own liens. And let me tell you what a nightmare that is, okay? Now, I'm heavily involved in national trial lawyer associations. I'll be the first to admit I have seen the ugliest of the ugly when it comes to some of these medical funding companies on a national level, okay? There's a reason we have a joke during GTLA annual conventions that we just don't know who's going to show up as vendors that year because they cycle through so often. This is a high-risk business for those people. They're bad doctors. They're bad lawyers. They're bad business people.
But no bad judges.
Judge Hamrick is the best judge in the world. Let me tell y'all something about my senator back there. I cannot thank y'all enough for not asking him any technology questions, because about 15 years ago when he bought his first computer, I had to go over to his house and turn it on for him. Is that a lie, Bill? Yeah, don't. Well, he can't. He need a microphone anyway. But watching this medical funding saga, not only the medical funding saga, but just let's call it the saga that's been going on at the Capitol this session. I think the good medical funders have been lumped in with all the bad ones. And quite frankly, the problem that we have with this bill is, sure, I thank you for amending the discovery. That's great. Okay, I was going to liken that to, when I go buy a cheeseburger, I have no idea how much it costs McDonald's to make that cheeseburger, but by God, I'm going to eat it. Okay, I don't get to know what medical funders pay for that treatment. I don't get to know what health insurance companies pay the doctors, and thank God I don't know, because it may make me mad. Okay, but with that said, taking out that discoverability is one thing, okay? But when I go to trial and I have medical funding in place, and my practice is not those runaway verdicts you see. I am your typical West Georgia car wreck lawyer, okay? These are people that may have been seen once in the doctor's office, twice in the doctor's office, in physical therapy. Okay, when I go to court and I try that case, the defense lawyer inevitably is going to stand up there and talking about the reasonableness of those costs. And I can tell you, last year, I tried 19 cases. I lost 9. Zeros. Not a single medical funder I work with pursued those clients. So what I want to see from this bill is, yes, there's great language in there about the bad actors, but to my knowledge, there's no penalty. And if these bad actors in the medical funding industry that come into Georgia from Las Vegas, that come in from Buffalo, there is one, from Philadelphia, okay, we're talking about people that if there is no penalty, or if that penalty's light, they're not going to care. So I hope that instead of moving this bill along from this committee, that the medical funders, and there are many great ones in this state, many, 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 will come together with the other side and talk sensibly about what needs to go on, and we don't rush this through so that we can add who knows what to it. Thank you.
Representative Lewinsky.
I'm going to be quick, and I've been doing this for 10 years, and when a guy had a PowerPoint the other day as a witness, he showed us a document that did have where they could go after the person who borrowed the money, and I've never seen in a medical funding where they could, and it looked at me on there that it was actually a pre-loan to the client, which is different than medical funding. Have you ever seen with medical funding where they were allowed to go after? Because I have never.
I can't say that I never have. Like I said, there are medical funders out there. I have, in fact, I inherited a case from a lawyer in Philadelphia who used a bad actor. And if my memory serves me correct, that language was in there. One of the things that I do in my practice is, regardless if the client is seeking medical treatment and they're going to use a medical funder, I've got a 3-page letter that I make my staff read out loud to them and sign before they're allowed to seek that treatment. Now, pre-settlement loans are a totally different animal. As some of you know, people can seek pre-settlement loans, just to pay their cable bill. And I have to explain to them, well, your cable bill is now going to be about $2,000. But it's a completely different animal. Pre-settlement lending that's difficult. Okay.
Counselor, thank you for coming today.
Thank you.
Appreciate you coming over. Dr. Amit Patel. Dr. Patel, did I pronounce your first name right?
Yes, sir.
Okay. Welcome. Good to see you. Please tell us who you are and who you're with, and we'd be happy to hear from you.
Thanks for having me, Chairman and committee. My name is Dr. Amit Patel. I'm a interventional pain physician. I'm with Summit Spine and Joint Center and Chief of Pain Management at Emory DeKalb Hospital. Trained at the University of Michigan and Emory University. Finished my fellowship a couple of years ago, 2010, excuse me. So I want to talk about two things. I think patient access and economics, right? So I'm a doctor, so let's talk about patient access. In 2015, I opened my practice in 2014. I had a patient who had gotten a pretty bad car wreck at a 2-level fusion at Grady Hospital, came to me, had no insurance at all, was in severe chronic nerve pain shooting down the leg. She qualified for a procedure called spinal cord stimulation. That's placing a battery pack in her back, creating pain relief and restoring her life. At that time, the option was I could hold a lien. I had 10 employees. I just started my business. There's no way I could hold a lien. The procedure cost me, from an implant standpoint, probably about $30,000. So I was introduced to a funding company. A funding company helped me, paid me for the procedure, and I was able to place the battery and create pain relief for this patient. This is a patient who's underinsured, had no option except this. If you look at globally healthcare, right, we actually, with funding company, we've used the ingenuity of the private sector to create access to care. We don't do that for healthcare across anywhere, right? We have underinsured Georgians everywhere, and I can't see those people. And so funding companies has done that. The other second thing is this bill makes it worse for the bad actors, right? I run a business. I created, to be honest, we had 3 employees in 2014. I have 170 employees now, right? And the ability to treat these patients has given me ability to give 401ks to my employees and health insurance to them, right? But if you look at why this bill is bad, funding companies will not fund doctors who have really, really high charges. So what do? They end up leaning the case over 1 or 2 years, right? And so if we do that, if we eliminate my practice, Dr. Polidor's practice, Emory Spine, right, you're going to get all of these cases sent to these unscrupulous physicians, and it's going to make the problem worse. So they can charge $300,000, $400,000 for a fusion, and that's going to be an issue. So there's a lot of things, and health insurance was another issue. Why not use health insurance for this, right? So that's a good question. But if you look at the local coverage determination of Blue Cross Blue Shield, of Aetna, of United Healthcare, if you're involved in the NVA, you can't bill health insurance. So we've had clawbacks, meaning I billed health insurance. My H&P said the patient was involved in the NVA, and Blue Cross came back and said, no, you should use auto insurance, not health insurance. And so that's an issue. The other issue is underinsurement. So deductibles, they're too high. Co-insurances, they're too high. So when the patient's out of work, injured, they can't pay. So medical funding allows that option. And so to me, it's what we should do in healthcare. We should create private sector options for these patients. And funding has done that. And sure, they're bad players and everything, right? I get it. But we've been able to help a lot of patients. So that's all I have.
Thank you, Doctor. We appreciate you coming today. Yeah, absolutely. Just press your button. That's what I'm looking for. Anybody who presses, I'm going to recognize them. Hold on a second, Doctor. Yeah. Representative Bruce.
Yeah, I'm trying to make sure I understand this in its totality. I know, and correct me if I'm wrong, the patient is not involved in the agreement, the contract. Is that correct? It's you and the
me and the funding company. Yep.
Okay. And if the patient comes to you as a doctor and says, I don't have the coverage, I don't have the insurance.
Health insurance?
And you're now trying to work out an arrangement for treatment, for payment. What is happening to the patient while you're trying to work out the treatment? I'm
seeing them, right? So typically the patient comes in, they've been involved in an accident, they have a personal injury attorney already, right? And so they don't have health insurance or underinsured. I'll see them as a new patient the first couple of visits. At that point, if they have an MRI or diagnostic issue, herniated disc or severe neuropathic nerve-related pain, we're going to go in and see them. At that point, I may have to do procedures, right, which cost money. And so then I'll get a funding company involved. They'll talk to the attorney, and we'll work out a way to see that patient.
Okay, but is the patient being, I don't want to use the word neglected because that'll put you on the spot, but
sure.
Is the patient not getting the treatment that he or she needs while you're going through all of this? How am I going to get paid process?
No, this is done pretty quickly, right? The attorneys look at it. I'm a physician, so the attorneys look at it. It gets to the funding company. They talk, and we see them as soon as we can. I mean, so the patients are not getting collected.
Thank you.
Thank you, Doctor. Appreciate you being here today. Tom Bryan. Mr. Bryan, thank you for coming today.
Thank you, Mr. Chairman.
Appreciate you being with us. If you would, please tell us your name and
Sure.
introduce yourself, and we'd be happy to hear from you.
Sure. My name is Tom Bryan. I'm the CEO of Medical Assurance Funding. We're one of these funding companies that's in discussion. I know that everybody on this committee cares about the citizens of Georgia, and that's why you're in the legislature, and we appreciate that. But it got a lot better, Mr. Welch, we took some of that language out earlier, but it's still throwing the baby out with the bathwater, we believe. The losers in this bill, unless it's improved some more, is uninsured or underinsured citizens that can't get health care. And I'm being a little bit redundant from some of the previous speakers. The only winner that we can see are the large insurance companies. Just one name that comes to mind made $8.8 billion last year. So I don't think they need a whole lot of help being looked after. The insurance companies are doing just fine. But it was already been said, if this legislation goes through as it's currently structured, good physicians, the better physicians that generally in the past have not seen medical personal injury patients, because it's been said they quite often have to wait 2 to 3 years to get paid anything, and in some instances they never get paid. So if this passes, these same doctors that we've just recently been able in the last couple of years to gotten to provide the care, they'll just stop seeing those patients. They don't have to do that to make a living.
Mr. Bryan, let me ask you, what is your background?
Banking.
Banking, okay.
Yes, I'm a recovering banker, yes, sir.
You're a recovering banker, understood. So what I would like to do, and you don't have to answer these questions if you think for some reason
Sure,
you can't, but what about the bill with that section gone does what you just said would happen?
I'm sorry, I didn't understand.
What about the bill with the section that we have deleted would do what you said would
So,
happen?
so if you can drag into evidence, it's just the optics of
that portion is gone from the bill.
Okay.
And
So
that's why, let me back up a second.
glad
For all the witnesses here, we wanted to have a discussion about what we might consider, not what we would not consider. And any member of the committee is welcome to correct me if I'm misstating this, because I'm learning a lot about this too. But that section of the bill is gone now. That's what we removed.
Okay. Then the part that's not, maybe I'm just not reading it correctly. It sounds like.
Do you have a copy of it?
Not in front of me, I don't. But am I correct that you're required to disclose to the patient and his lawyer what was paid to the physician for that lien? Am I not correct about that? So that's part that's been struck.
Yeah. Well, Representative Welch, you want to respond to that?
The disclosure provisions are that any agreement between the medical funding provider and the customer's health care provider regarding payment for services shall be disclosed to the consumer at the earliest time of that treatment is rendered, or the time the agreement is entered into. So that's a consumer protection measure between the medical funder and the consumer. The lawyer's not involved in that. Secondly, it also requires that the amount of the medical funding providing to pay the consumer's health care provider for the service will be disclosed to the consumer at the time of treatment or at the time the agreement is entered into. Those are the two things that provide for consumer disclosure, so they understand what they're paying for, what they're not paying for, what they're receiving and not receiving.
Okay.
The language that had to do with disclosures in the lawsuit has been deleted.
Okay. So, as I understand it, would that not impact the consumers when it comes time to settle the case? And in our case, I can't speak to the other funding companies, we have the attorney and the patient sign the document says they understand that whatever our usual and customary bills are that we purchased will get paid when and if the case settles. If it doesn't, we don't get paid anything.
Right.
And I'm pretty sure the other funding companies are exactly the same way. So my question is, or our concern is, that's going to be used to impeach the validity of our bills. And our impression is the focus, at least before you made these changes today, on the bill was the size of the bill, not the reasonableness of it. There are systems out there that are very easily, and the insurance companies have their own. It's called Colossus. They all went together and built it, and they can figure out what's fair and reasonable for any specific medical procedure that can be done. So there are plenty of ways that they can be made sure that the bills are reasonable. And I assure you, the insurance companies aren't paying bills that aren't.
And I don't disagree with that. This doesn't affect any of that litigation methodology, whatever it is that's going on in terms of the courtroom, proving whether or not the bills are reasonable. This legislation has removed all that evidentiary issue, all those evidentiary issues that were in the original bill. And the last element that dealt with the litigation aspect of it was the discoverability of the contracts, mandating that those be discoverable. And that language has been struck in this version.
Okay, then I know when to shut up. Thank you.
Well, hold on one
Sure,
second.
sure.
Representative Silk, was that you, Representative Walensky? Go ahead. You may have a question of the witness, so hold on.
I had a question regarding Chair Welch's response.
Well, sure.
Okay.
You can be dismissed. Thank you very much. We'll
Thank
let
you.
them talk to each other.
Thank you. So I'm just trying to understand it again. With the bill we have left, is the bad actor the funding company, or is the bad actor the medical practice, or who? I'm just trying to figure, because we're putting guardrails again. I can't figure out who the bad actor is. So who's the bad actor that we're trying to put guardrails on?
This actually requires that now there cannot be kickbacks, as you mentioned before, through the medical funding or offers to law firms or healthcare providers by a medical funder. So that would eliminate that. That would also require that the consumer is fully informed in making the decisions of whether to sign on to medical funder. You just heard the testimony that we had here, that the medical funder actually works with the attorney and the client. This would ensure that they have full disclosure of what the medical funder is providing under the medical funding agreement for the consumer. And obviously the lawyer, and if the lawyer is representing the consumer, then they'll be providing advice accordingly, one would presume. In addition, the remaining provisions there say that the medical funding provider shall not do 1, 2, 3, 4, 5, and 6. That rolls from lines 49 through 66, and I don't think I need to read all that out, but I'd be happy to.
Okay.
And if I would, Mr. Chairman,
Sure.
It's interesting to hear the testimony that we had, because the testimony we had today just confirms that there are bad actors.
Well, the chair can tell you, and those around the table are welcome to disagree with me, that has been a consensus of what I have learned, and I think the committee has learned. This is a valuable help to people who have been injured, particularly those without insurance. And there are good actors in this business. In fact, what the knowledge I'm gaining is that most of the actors are in that category to some extent. There are some bad actors, just like counsel earlier that was before us said there's bad doctors, there's bad lawyers, any profession, even bad bankers. I've met one before. But what we're trying to do is try to figure out how to weed out the bad versus the good, the sheep versus the goat, so to speak. And so anybody who is going to come testify, and I've got about 4 more that have signed up, I think, if you're trying to convince us that there are people, this is a help in certain situations, and we shouldn't eliminate the whole industry, that is not what I think anyone's contention at this table is at this point. So, having said that, Joy Taylor. Ms. Taylor, is that Joy? Is that correct? Joy Taylor? Ms. Taylor, we appreciate you being here today. Thank you for coming. Please say your name and introduce yourself,
Sure.
and we'd be happy to hear from you.
Thank you for having me. My name is Joy Taylor. I work with Polaris Spine and Neurosurgery, which rebranded from being Peachtree Neurosurgery in 2015. I joined the group in 2004 to help run the business. At the time, I was a recovering lawyer, much as Tom was a recovering banker. So it didn't surprise me at the time that the group didn't have any means or system to take personal injury patients. What's maybe been the most striking for me in being here for 3 days now, listening to some of the testimony, has been that since we started participating with funding companies in approximately 2015, 2016, in those years, we've never had a patient be asked to pay. There's that patient would be victimized a second time if they were asked after all they'd been through. All of these loans that are gone through and all of the paperwork reflects a non-recourse system. Medical funding has enabled us to care for patients who previously have not been able to receive care. We would receive patients who were referred to us by the emergency department. But we're a healthcare company. We're not a case management company or a lien filing company. We really didn't have any means to be able to take this on, not to mention the cash flow issues. That's a very real thing for any medical practice that we have to be vigilant of. But however, with this premise of non-recourse, we've never had a patient held financially responsible because we as the treating physician are not going to be able to sit there and look at that patient if all of this breaks loose and they're being held responsible with no possible recovery, which is unfortunately a very real aspect of personal injury. Without this, these injured patients would not have care, which I think we've all talked about, and I think I'm heartened to hear is being accepted as a basic premise. But again, I'm a little confused if the concern is the injured patients. These patients are not being asked to pay. So it's a little confusing to me as to what's really driving the concern with these medical funding companies, which have broadened the field of physicians willing to provide care in a way that didn't exist when it was all done on liens.
Are you telling us that there are no bad actors in this industry?
Well, I can't say there are no bad actors in any industry. I think there are bad actors in any business, including what all of us do every day. That's just a reality of humanity.
And I'm not being facetious with you, but I'm trying
Right.
to understand what you're trying to communicate to us.
Well, I think what I'm trying to communicate is that it's a value, and I'm not entirely certain how this language does any benefit. The patients are involved in this system from the beginning. Their attorneys have to sign off on it. The patients sign off on these agreements as well. And again, for the language being struck, my understanding, at least, of the process is that it could very well be added back in the Senate. And then I don't really understand at that point how we are going to prevent the discovery aspect from being part of the final bill. Again,
you are correct. The Senate does bad things.
And there, I'm sure,
we will all
just
agree
those
upon
bad
that.
actors. What are we going to do about that, Representative Fleming?
And I interrupt you again, so please continue.
No concern. Again, I just, as a practice that has been around since 1979, but it has only recently begun to be able to take care of injured patients, I did feel it was important for our voices to be heard. We've taken care of, again, this is probably 5% of what we do. And again, many of those patients don't need surgery. Sometimes they need pain management, which we do as well, and sometimes they just need some physical therapy. But it's broadened the care that these patients can receive in a way we feel is valuable, and we wanted to share that. So.
Counselor, do you have any recommendations on how we might deal with the bad actors that I think you acknowledge you just don't know how many there are?
Well, I think that I don't know that there is a bad actor component that doesn't take care of itself in this market. Essentially, many of these companies come into being every year, and many of them go out of being every year. I do think that the ethics that the attorneys have to uphold mean that they work hard to make sure they're only doing business with reliable companies, because at the end of the day, that's their client. And they have to explain to that client why they're being held to pay for a bill in some crazy world where there's been no recovery. And they wouldn't allow that to happen. In the limited time, again, 4 or 5 years that we've been involved in these kinds of cases, I've just not seen that. I think these attorneys take that responsibility very seriously. And I largely think the problem takes care of itself, which is part of why I've been so confused about this bill, frankly. So again, that's our experience.
Thank you.
I hope it's helpful.
Hold on a second. Representative Lewinsky?
This is my last question for the day, Chair.
You can ask more than this one.
If a attorney has a client and they put a contract in that client owes money, and at the end, without the client signing, the client then owes money, that's legal malpractice. Right?
Absolutely. That would be my understanding. And again, I think that largely sorts itself. Thank heavens. So.
Okay. Thank you. We appreciate you being here today. Reed Zetzing. Reed, you're going to come up and tell me how to pronounce your last name. Good to have you today. Please introduce yourself. Tell us your name, and we'll be happy to hear from you.
Thank you. It's Reed Sizing, and with Live Oak Survey.
Sizing?
Yes, sir.
Sizing. Thank you.
And I don't have much to add and don't want to waste the committee's time versus what Dr. Patel outlined. The one thing that I would say on...
And I'm sorry, who are you with again?
With Live Oak Servicing.
And they are...
Medical funding.
Medical funding, absolutely. Yep. Go ahead.
And the disclosure really of every business's cost of goods, it's not practical, it's not relevant to an underlying case. I don't think it's a precedent that you want to set. A $2 t-shirt made, sent to a $4 distributor, at $8 to an exporter, at $16 to an importer, at $32 to it. Like at every single stage, are we disclosing all cost of goods in all businesses? It just doesn't seem practical. It doesn't seem that there's a multitude of inputs and risk factors in this business. And with non-recourse, the patient in the end has received care. We've taken all the risk and oftentimes are not repaid.
And what is your background?
My background, originally I started on Wall Street as an investment banking analyst. I did a 2-year program. I moved to London and Paris, where I also pursued investment banking. I went to graduate school in Boston, came to Atlanta to run European capital markets for Robinson Humphrey for a number of years. I started a company and took it public. I took another company private, and I've seen lots of businesses.
And the reason I ask these questions, number one, we'd like to know who we're speaking with, but also if we're talking to a doctor or a lawyer or someone in the investment community, that helps us sometimes think of the questions we may want to ask you about. So one I would have for you, and I'm going to let you continue, by the way, but the counselor that we had up here before you agreed that there probably are some bad actors in this industry, and my question was, how do we regulate, affect, get them out of the business? And the first question for you would be, before you answer that second one, do you agree? Are there bad actors in this industry?
The bad actors that I have personally seen in this space are doctors who run either dual charge masters.
Tell us what that means.
One for commercial payers and one for non-commercial payers. And the medical funding community, including those that testified here today, don't fund with those players. So it's actually missing the point. It's not the medical funding community allows the places that we all collectively would have surgery are places that would otherwise be unavailable. Why shouldn't we make the doctors at Resurgence and Peachtree Orthopedic Clinics and the quality doctors that we would all see, given that we're blessed to have healthcare insurance, why wouldn't we make that available to people who can't afford it?
Why do you assume we don't want to?
Because the medical funding bill, and it's gone through a number of iterations, and we didn't get a copy of the most recent. I understand even the last copy that I have, striking those lines, it doesn't exactly match. But it appears to be down to two things. Number one, that medical funding companies won't pay commissions. We never have, and don't have any issue with that. But is that an entire bill to pass through? The other is the disclosure of all cost of goods to a consumer. And I just ask the committee respectfully that is that a capitalist society endeavor that we want to take through all industries? It doesn't seem to make a lot of sense.
Okay. Is that you, Representative Rutledge? No? Okay. I did interrupt you with some questions, so if you had a line of thought you wanted to wrap up with, I don't want to stop you from doing that.
Just thank you.
Okay, thank you very much. We appreciate you being here today. Okay. Jonathan Newton. Jonathan, welcome. Good to have you today. Please introduce yourself, and we'll be happy to hear from you.
Yeah, I'm Jonathan Newton. I'm a physician. I'm an interventional pain management physician. I came straight from the clinic. I don't normally wear my pajamas out, so I do apologize.
Well, you look like you should know what you're talking about.
Let's hope it's not deceiving.
So, but tell me this, where's the accent from?
I'm English, but I grew up in South Africa. I've been here for 30 years, though.
Okay.
So I'm one of all y'all now, so.
Yeah, absolutely. Good to have you. Please continue. So you are
I'm an interventional pain management physician. I'm both
okay.
anesthesiology board certified and pain management certified. I own my own clinic. I'm a solo practice. I'm a small group.
Thank you, doctor.
Thank you. I do 70% of my work is Blue Cross Medicare. About 30% of it is personal injury. Of that, I probably hold more than I fund, but I do both hold paper and fund through funding companies. I realize that there's been some changes to the bill. We don't quite know how it's going to come out. If some of that comes back later on, it's going to have a pretty devastating impact on the funding. And as people have told you guys already quite a few times, with the rate of uninsured, with the high deductibles, there are a lot of people who just cannot get treatment with a car accident. By carrying my own paper, carrying my medical lien, or by using a funding company, there is no money that comes to me from the patient. The patients are not out a penny for any of their care, whether I carry the paper or it's a funding company. Any settlement comes from the attorney. The patient is involved, they discuss that with their attorney, they're aware of whatever it is we get paid. We don't control how much we get paid. So there is really no downside to the patient on this that I see by allowing funding, and certainly also allowing patients to work with the doctor to carry the paper. There are bad actors. I hear the story of bad actors all the time. Come on, bad actors and everything. We can't eliminate that. That's just not possible. And I do think there are measures to help with that. But you do have an adversarial court system. Isn't that what that's for? I mean, why is it that we have to legislate that when you've got very wealthy insurance companies?
Well, we also have the free market, and I know some lawyers that I wouldn't go see, and I know a lot of them, they go out of business, but we also have this thing called Supreme Court, and they can disbar me or any other attorney if a complaint is brought against us for doing something wrong.
Brilliant.
And we have this whole list of ethical canons that we have to follow by. So even though we have an area with problems, like every profession, we do sometimes enact laws and regulations that try to improve the situation. And the question before us that we've been asking regularly, is there something we can do here in this area to help that out? And I'm not trying to make you say that there is, but it is the question that we're asking.
It is. One of the things I have to ask is, my understanding is that there is already at least federal anti-kickback law, correct? So as a physician, I cannot pay you to send me your patients after a car accident. That's against the law. I just wonder the necessity for repeating it. Doesn't that create problems? But that's a legal question. I have no bloody idea what about that. But basically, my fear is, going forward, there may be some changes to this that could negatively impact funding, either by a funding agent, and I think these guys, ones I work with, ones I know, they don't come after the patient. I also don't want to see negative impact against physicians who carry. I don't go after the patient. I mean, why go after somebody I can't pay you anyway? I mean, but that's just, no, you don't do that. It's not appropriate. Nobody wants to do that. Thank you for your time. I appreciate it.
Thank you, Doctor. We appreciate you taking the time to come out today.
Thank you.
Thank you. Okay, our last witness is Emily Bagwell. Ms. Bagwell, please come forward and introduce yourself, and we'll be happy to hear from you.
Thank you, sir. Mr. Chairman, members of the committee, my name is Emily Bagwell, and I'm here today on behalf of the Georgia Association of Property and Casualty Insurance Companies. And I want to thank the committee for wrestling with this issue. I know y'all hear a lot of issues that you have a lot of testimony on, but this may be towards the top for the year. And I really appreciate y'all taking the time to work through the bill, change it, and massage it as hopefully the committee sees appropriate to move forward. And just really, that's all. Y'all have heard a lot about this, and I just want to thank y'all for your time.
Thank you, ma'am. We appreciate you being here today.
Ms. Bagwell, do you? May I ask a
Sure, go ahead.
I'm sorry.
Come back up, Ms. Bagwell. And then I have one other question for you, too.
Ms. Bagwell, do you support the measure if, as it has been presented to the committee, which is under a motion with the due pass, with the striking of the sentences, the lines at 36 through 48? Do you have any comments or questions about the striking of that language? And if so, what are they? And if not, do you support the measure moving forward without that language?
Well, yes, sir. Of course, we would, in all honesty, prefer to see the language in there, but I also understand that this is a process, and I appreciate you being willing to work with it and striking the language. We're absolutely agreeable with that. Yes, sir.
Representative Rutledge.
Thank you, Mr. Chairman. Is it on?
Press the button again.
Hello?
Yeah, it's on now.
It is? Okay,
Yeah.
good. And I'm sorry I missed all the hearings, all these committees you have to go to. So how does this play out I'm a consumer. I can't afford the care.
Yes, sir.
Lines, 27 through 35. How does that help me as a consumer to know what the doctor or what they recovered, what they were? How does that help me as a consumer? I couldn't afford the care to begin with, so I'm trying to understand how it would help me, for me knowing. Andy, maybe you can help me understand that as well. I don't.
Well, this is because the medical funding provider is going to be is funding and there's going to be health care provided.
You're not on either.
So, in deciding, you've heard from 4 different medical funders.
Right.
There is obviously a market for this. And as a consumer of that, if I'm the injured party, I'd like to know what my best deal is going to be. And I'd like to know what I'm getting as a consumer of these medical funders, and what my options might be.
I'm more concerned about the care I'm going to get rather than the money.
Exactly. So that's what this disclosure does in terms of the cost and care and the manner of treatment that would be rendered prior to getting the treatment or prior to contracting with the medical funder. And so I think that you ought to know that. I agree with you. And I think that this disclosure language helps the consumer make that decision. And we've heard from 4 different ones. We've heard from at least 3, I think 2 other different ones prior to this. So I've heard from 6 different ones. This market's pretty well saturated with different funders. I think as a consumer, you'd want to know what you're getting. When you're signing up, and understand this, they've said non-recourse, meaning that if they contract with the medical funder to fund their medical attention, right, their treatment, then if that treatment and the funding of that treatment consumes all of the settlement, then that's what the medical funder gets to keep as assuming the risk for taking on and providing and funding the medical treatment. They're buying the account, the lien from the doc.
I get that, yeah.
Yeah, and then they're saying, okay, I'm betting on the come. I'm betting on the case settles or jury outcome is such that I get X number of dollars over and above what I paid for that account or that lien. And that could be all of it. That could be all of the settlement money that you as the injured party might be otherwise expecting. That would be a full non-recourse. In other words, you don't go anything beyond that. The terms of the contracts may vary, but at least with the folks we've heard today, there's nothing, they're not going beyond that settlement proceed or what they've contracted for. And so I think knowing those terms are important to you because you ought to know if it's going to consume all of your settlement proceeds or a fraction of them. But you ought to know that. And I think that that's part of the disclosure process here, that if there's a market and there's a free market, then it has to be an informed free market in order for it to work. So that's the points of those sentences there.
Representative Lewinsky.
Thank you, Chair. I'm not going to ask a question. I'll just make a quick statement. I know Chair Welch has had a lot of testimony on this, and I don't know if he's a defense attorney in this area, but I've been doing it for 10 years. No. Okay. So I've been doing this for 10 years, and at the end of settlement, you work it out with everybody. They are never on the hook. This is not a problem.
All right. Representative Welch.
If I might, Mr. Chair, I just wanted to make a couple of closing statements. We're in the posture of trying to.
You can be
Okay,
excused.
thank you.
I'm sorry. I didn't realize
fine.
we still had you there.
So lines 29 through 35, we just talked about. I think Representative Rutledge asked a very good question and wanted to understand what that disclosure was, why it's important. And I think I've addressed that, and I won't go back over that. But what we've also heard in the testimony today, not to mention the 4 other hearings that we've had on this. So to the counselor's statement that this is rushed, we started this, the bill was filed last session. Hearings have been held all session long from the first week to the present week. So it hasn't been rushed. It has been vetted by this full committee now twice, the subcommittee 3 times. So what we heard in this process, the lengthy process, is that in every case, the funding companies that have come before us have all said there are bad actors. How many? We don't know. We're not going to say. We're not going to name names. They're bad actors. And from the first hearing, GTLA's president came and said, we're against the evidentiary requirements that the original bill had, but we are for the regulation of funders. And so that was the testimony that we had from Dan Snipes from the first meeting. So GTL's position was take out the evidentiary issues, remove the collateral source rule issues, and then we're good with the funding mechanism regulating the medical funding industry. What is left in this bill after it has been gutted down to just a consumer protection measure is the very things that every single funding company has said. These should be non-recourses, and it is abhorrent and against our industry. We do not participate, want, or desire any medical funder going after a patient. These should be non-recourse loans, and that's exactly what lines 65 and 66 say. Those were added in subcommittee. In addition, we have talked about that there should not be any payment or commissions made off of getting these loans, and that the loans themselves, the funding agencies, shouldn't be driving or incentivizing doctors to act outside of their duties to their patient, or lawyers to act outside of their scope of duties for their clients. Those prohibitions are here, and we all agree that that's the way we should act. And so in doing those things and saying those things, we're saying and codifying that these aspects in terms of Georgia public policy, in terms of the law of the state of Georgia, medical funders, the good ones do these things, so it doesn't impact good funders. These prohibitions would work against those that are working to corrupt that system. And those individuals who want to try to take more money from the patient afterwards, or those who might engage in commissions or referral fees to gain benefits, those that fail to provide information to the consumer, the person at the very end, every one of these minimal lines that are left in this bill do all of those things to ensure those protections are codified in the state of Georgia and that are not acceptable. And so I would ask the committee to codify these things, because the medical funders have all said those things shouldn't happen. They don't happen with my company, and those are what bad actors do, and there are bad actors, but how many we don't know, we can't say. And finally, let me say this. The chairman, myself, Chairman Fleming, has asked for language to work on a solution with medical funding providers who have said over and over, we will not give you language, but we will tell you all the things that we do not do. This bill codifies everything that you do not do and you think is bad. And so I would ask, if that's the answer we're going to get, then I think you have your answer, which is in this bill at the present time. And the final point I'd like to make is that understanding these essential ethical guardrails that it puts around the industry, none of these prohibit the good actors we've heard from doing the exact same thing they're doing today. They'll be able to do it tomorrow, and if the bill is ever effective, thereafter. Nothing about this bill prohibits the good funding actors from behaving correctly. And I would submit to you that this will allow for consumers to have information, to be protected, and to receive the medical treatment they want using this private and well-heeled funding mechanism that is out there.
Representative Bruce.
Mr. Chairman, I agree that it hasn't been rushed, but it hasn't been resolved, even though we've been talking about it. And as I look around the room, I see heads nodding, and people are confused about what to do with this. So and we keep talking about good actors, bad actors, but we really haven't defined the bad actors. I know we saw the video, but it looked like it was a mixture of things that I saw in that video, some of which had to do with this and some of which did not. So it's still somewhat confusing. And I admit, I'm not a lawyer, but all the rest of you guys are, and y'all still nodding your head like you're confused. I'm not. Well, not you, but some others are. But some are. So at the appropriate time, if possible, I'd like to make a motion.
There is a motion already on the table right now. And the chair had an interesting discussion about a prior bill on this issue of motions in the committee. When the chair recognizes you, he recognizes you to ask a question.
Well, that's what I said, at the appropriate time.
Absolutely, but I want to clarify this because it came up once before. On the floor of the House, we're not quite as formal here as on the floor of the House, but if you will notice when the Speaker says, for what purpose does Representative Bruce rise? Mm-hmm. And if you tell him to make a motion, he may or may not recognize you to make a motion. If you tell him parliamentary inquiry, he usually will allow you to do that. So the chair here in this meeting does not say for what purpose does Representative Bruce press his button, but that's what I'm doing. I'm recognizing you to ask a question.
Well, that's what I did,
and you did, and I appreciate that.
Yeah.
But only say that because that came up before. So the chair is likely to have the motion in front of us resolved before I go on to an alternative motion.
Okay.
If that makes sense. But I appreciate the gentleman's question. Representative Rutledge.
Yeah, just thank you, Mr. Chairman. Lines 50 through the end of it, what they shall not do. If they do, what happens to them? If they do any of these things, what is the recourse? What?
Yeah,
and how do we catch them?
Well, I think those are good questions in terms of ultimate enforcement, and because we're at the point where this bill has been reduced down to a consumer-based bill, and my intention would be to work on solving that. I can't say that it doesn't already exist within this code section because I haven't looked at the chapter for that purpose.
And I can assure you I haven't.
So I would do that, but this particular chapter is exceptionally lengthy, and I'm fairly confident that it already has enforcement mechanisms with it, because you can see we're actually adding sections 481 and 482 and 480. So it's got 400, almost 500 sections to it already. So I suspect there's already enforcement mechanisms in here, and I would prefer that it move forward. And to the extent that I need to go back and add a specific enforcement, then I will, but I don't think that's necessary.
Whenever I get asked that question, what can we do to the person that we catch doing this? Quite often, when you violate a statute, it leads to the potential of rise of a private right of action. If you can prove damages, then their duty was caused by this statute. Does that make sense? In other words, you can sue them if you catch them doing this, and that's quite often what happens. Because this isn't a consumer protection provision, also there are components of the Attorney General's office and other consumer advocates that do have investigatory authority. The other thing it does is that when we have someone that is consistently breaking a statute, sometimes we come back and put specific penalties in later. And we tell you what the rules are. If you don't, we catch you not abiding by them a lot. That's cause for new legislation at a later time. Okay. We have in front of us a do pass motion. We have other amendments that may want to be offered at this time. Press your button, Representative.
I appreciate that, Mr. Chairman. At this time, I think we've had exhaustive testimony, and I wouldn't want to take any more of the committee's time.
Okay. Are there any other amendments? Hearing none. Any final discussion? There's a do pass motion as amended by substitute in front of us. All those in favor, please indicate by saying aye. Aye. All those opposed? All those in favor would indicate by raising your right hand. All those opposed? Bill fails. Okay. That is the last bill on our agenda today. Am I correct? Yes, it is. Thank you for being here today. We stand adjourned.